Moving on to further. The application before me was filed on the 21st of December 2024. And have been filed by the DPP seeking from orders that the 23 respondents of before this court be detained for 14 days to enable their applicant, that is the DCI sent to Nairobi to complete investigation. They have relied on the grounds on the face of the application, together with the supporting affidavit, sworn by Corporal Anthony Kerini. In brief, they state that the 33 respondents were arrested in Nairobi CBD and that they were booked via Central Police Station, that an OB was provided for the same, that the mobile phones of the state suspects were taken, and that are to be subjected to Communications Authority of Kenya, that they are to extract messages, WhatsApp messages, Facebook, X messages, photo statements that are inciting to members of the public against the state. That they are yet to obtain CCTV footage, record witness statements, and tranquility within the country, and that they are a threat of peace and stability. We had many counsel appearing for the respondents. They have given their response. Among them, they have quoted sections of the Constitution on the rights of the accused person. They have also raised the issue on conditions of the accused persons who have been availed before this court. They have also stated the law on what is to be considered for the grant of bonds, which is compelling reasons for the court to consider. They have raised the rights of an accused person to picket and to hold peaceful demonstration. They have also raised an issue that the affidavit that is before court does not disclose any offense, but they are mere speculations. That the investigations to be carried out do not require the presence of the accused person, and that the court has the discretion to grant the bail and bond to the accused person, and that the same has not been objected to. that the prosecution have not demonstrated the disharmony or the breach of peace that is being alleged, that the affidavit seeks an omnibus incarceration of all the 23 respondents who are to be held in custody for 14 days pending investigation, that the same is arbitrary and an abuse of the court process, that the investigations are already prejudiced, that court orders were not obtained to extract information from the said phones belonging to the respondents, and that the court has to balance the rights of the accused person while looking at the said application. In my analysis and having heard all the submissions that have been made by the prosecution and the defense, I have considered the law, the issues that have been raised. I have also considered the nature of the offenses that have been stated in the said affidavits. I will agree with the defense that the same are misdemeanors. I have also looked at the said application and the number of days that is being asked for, which is 14 days. The prosecution, in stating, making a request for the said date, has also stated that there are some aspects of the investigations that will not require the presence of the respondents before this court. This has been raised by the respondents' counsel. The issue of the CCTV cameras, recording of witness statements, will not require the presence of the accused persons in custody. More particularly, what has been stated was that the accused person are a threat to breach of peace. Therefore, from the evidence, from the material that has been placed before me and the law, looking at the compelling reasons, the court has looked at what has been submitted and agree with the defense that the court has to balance the rights of the accused person while granting the orders that has been sought. In considering the nature of the cases that the IO wishes to investigate, the court also considered Article 29 of the Constitution, which provides for the rights and freedom of the accused person. It states that every person has a right to freedom and security of person, which includes the right not to be deprived of freedom arbitrarily or without just cause. The same should be done without, if the same is done without trial, the same should not be done without trial except during a state of emergency, in which case detention will be subject to Article 58. Article 24 of the state constitution also on the rights and fundamental freedom on the Bill of Rights shall not be limited except by law. Therefore, in my analysis, so far as the bond and bail is concerned, there must be compelling reasons not to grant the same. The court bond promotes values that underlie the open and democratic society based on human dignity and equality, equity and freedom. It therefore follows that the function of bail is to ensure presence of accused person to attend the trial. Be as it may, the nature of the offences as stated does not disclose or warrant detention of the respondents. The state have failed to prove that the investigation will call for limitation of respondents' liberty and require them to facilitate or conduct investigations. However, I would wish to point out that justice demands thorough investigation, and at the end of the day, if investigations reveal that the respondents are not culpable, justice will have been served. and the course of justice, therefore, will not be a smooth ride. And based on that, I will allow that I'll make the following orders, that the 23 respondents hearing will be released on bond. I hereby grant them a bond of Kenya shillings 50,000 with a surety of similar amount, each one of them. 5,000. I will also direct that they report to the investigating board. For pending investigations, we'll mention the case after 14 days.
So they're being released on a bail of 50,000 and a surety for the same amount. Quite unfair. They will reappear in court in the next 14 days.
Your tremendous respect. We appreciate the ruling of the court. And before Senior Counsel will say anything, I just want to point out one thing. Your Honor, it is the 31st of December 2024, meaning that tomorrow will be a new year. Just on that basis and on the basis of humanity, and I have spoken to my colleague from the DPP, as we welcome the ruling, I am making an application to review one term, just one, on the cash bail. I am proposing this. I am making a proposition that because it is a new year, Your Honor, you do review the cash bail term to a personal bond, or because we are all officers of the court, you review it to 1,000, which I shall pay personally as an officer of the court to secure their release today, so that on the day that the court will order they come back, we will come back on that day. 5,000 for most of them, if not all. I believe the good senator also has not seen his parliamentary service fund. He will not be able to get off. So even for the senator, I will pay the 1,000 for him. I am asking on humanitarian grounds that you do review the cash bail, and all of them may be sick. Just 1,000. My good colleague from the PPP, I have spoken to him, is also a man of God. He says that he does not see the challenge in the review. Just that. Just that. It is because of your voter.
May I open your honor? We can't do it. But as my other friend has said, we are all even millionaires a long time ago are now pauper. I don't have 5,000 in my pocket. I have to tell you the truth as a Christian, I do not have 5,000 in my pocket. Honor, where the cash there? Let these young people, they are poor people, let them go and join their families and celebrate the new year with their families. They will be here. No one wants to leave Kenya. Kenya is the most beautiful country in the world. Please qualify the regime. Thank you. My friend has put a right on. It's appropriate. It's the most beautiful country, except we have for a long time lacked property.
As a man of God.
Your Honor, we hear that word very much in the
He means it. Your Honor,
whatever amount you put, that there also be a right that there will be a contact person. For each and every 23 of them for the attendance.
There is a senior counsel.
I don't want senior counsel to be taken for
if we say contact person, it will complicate, and with the time remaining, there will not be
Yes. Yeah.
I offer to be the contact person for the 20.
Thank you very much, Madam. Yeah, thank you very much.
So you already seen the deputy has not proposed the limit to 1,000.
No, I did not say the amount.
I already have it on M-Pesa. Anytime the court directs you, just throw it to case. We walk out with our fellow brothers.
Freedom fighters. Yeah, when this president is security, it's not impossible. The very fact that there are court, some of us who are here in this courtroom, means that they are already. If they don't obey the court orders, I will definitely not come to the court. The very fact that I have caught me here, it's not the court master, our former minister of justice, means that they are people who drive the court. The young people, poverty stricken, hungry,
And broke.
and drugs. And for holding the law. And for holding the law.
Okay, then how about that?
Your Honor, one word. Permit me to my colleagues of the fight. Wish you are happy and prosperous.
Honor, before you get honor, we have the them to make an application that they have mobile phones and personal belongings to the restaurant.
I would allow our senior to close once. And wish the court has been.
Dr. Cabello has already reached the court. Happy New Year. And all the court attendees and all those present, including we no longer need a contact person. You did not put that condition. Yes, we'll be present.
Happy New Year.
Happy New Year! Happy New Year!
Taifa Kimani utumwe tupatie 1000 ya KFC. Ujue tuko na pesa.
Make sure sound in the
Ni mingi sana kusaidiwa zingi.
Kuna mwingine atakusaidia?
Ni mingi.
I shall be very brief because I've got a new engagement. My right here now, just now. He has a sense of fairness, he has a sense of justice, and that's what those of you who are young may not know that very much about the history of this country. This country is where it is because of the judiciary. We have had judiciary on the whole. In recent times, one can say has been strong, has been independent, and we should continue to support it. Without the judiciary, without the strong rule of law in the country, we would probably not be where we are. We still feel that we should have hope, continue to have hope in the judiciary. And these magistrates have shown us what it is, that as we start the new year, we should proceed united and make sure that the rule of law in the country is upheld. It is unfortunate that the conduct and behavior of what is going on, our young men or young women disappearing from the country, is disgraceful and despicable. No wonder that some individuals have decided to go to The Hague and file a suit there because of what happened. People just disappearing in the country is something that happens in our country that one can.
Bibi Mwangi. Mimi naitwa Gerard Mwangi Karicha.
Gerard
Mwangi Karicha.
Mwangi Karicha.
Yes.
Na mtoto wako ni?
Mtoto wangu anaitwa Gide Wanyeri Mwangi.
Billy Mwangi ambaye ni fourth petitioner. Yes. Mzee, endelea.
Mtoto wangu alichukuliwa kwa kinyosi on 21st Saturday around saa 9 akigojea anyolewe.
Yes.
There came two cars.
Yes.
One of the cars was Fielder car, white in color, the new model.
Yes.
Registration number KDG 527D.
Yes.
And the owner of that car had surveyed my home neighborhood for three days.
Yes.
The other car was a Bukidi pickup, which was behind that Vilda car.
Yes.
When they came to where my son was,